Hello, my name's Dave Day. I'm a Deputy Attorney General, actually, we're going to pause the recording. Okay, we're on the record. Once again, my name's Dave Day. I'm the substitute hearing officer in this case. This is in the matter of Red Hill, and the notice of violation that was filed, or pardon me, the emergency order that was filed or promulgated on December 6, 2021. Let's see, pursuant to Rule 11-1-31, this is a pre-hearing conference, which is on the record, but currently closed to the public. Pursuant to the order which was just issued today, we have a hearing that is scheduled for 9 o'clock tomorrow morning on the merits. May I please have appearances, please?
Good morning. My name is Wade Hargrove. I'm a Deputy Attorney General with the Department of the Attorney General. I am representing the Department of Health in this matter.
Good afternoon. My name is Craig Jensen. I'm the Associate General Counsel for Litigation for the Department of the Navy, and I'm representing the Department of the Navy in this matter. With me is David Fitzpatrick. He also is a counsel within the Office of General Counsel for the Department of the Navy. And so the first thing I'd like to give you notice of is that I'm not a member of the Hawaii State Bar. And so with the former hearing officer, pursuant to HAR 11 Tech 1 Tech 32B, I asked him to allow me to participate in this hearing as a substitute for Pro Hoc Vice with Mr. Fitzpatrick, who is a state bar attorney, and he issued an order that so allowed that. And I would ask you to issue the same order.
Let me just consider the rule. Okay, and in what state are you barred? Are you barred, Mr. Jensen?
I am, sir, in the state of Washington.
State of Washington. And you are in good standing?
I am, sir. I can provide you my bar number if you like.
Just for the record.
Bar number 21358.
And there was a previous hearing, pre-hearing conference in which the hearing officer had stated that he would admit you pro hoc vice.
He actually issued an order, sir. I can provide you with a copy of it.
And if it pleases the hearings officer, I have no objection to Mr. Jensen's participation in the proceedings.
Okay. What is the title of the order?
I don't have it in front of me. If you give me a second, I can go and get it.
Sure, just that would be just so we can get this out of the way.
Yes, sir.
All right, we're off the record. Apologize. Sorry, we're gonna have to do a little bit over again. I apologize. Sorry, this is back on the record. I apologize. We had a previous discussion that we believed was on the record, and we're just gonna have to just repeat this real quick. Mr. Jensen, I'm aware of a December 9th, 2021 order regarding association of counsel. Mr. Hargrove, you do not have an objection to the participation of Mr. Jensen under, pardon me. The rule again was, Mr. Jensen, you cited it before.
Okay. Rule is 11, TAC 1, TAC 32B.
Mr. Hargrove, no objection?
There is no objection
Okay.
to Mr. Jensen's participating in these proceedings under the conditions he described earlier, which is his association with local counsel, Mr. David Fitzpatrick, who is, as I understand, licensed to practice in Hawaii.
Okay. And Mr. Jensen, you agree to subject yourself to the Hawaii rules of professional conduct for purposes of this hearing, correct?
Yes, sir.
And then therefore, in my discretion, as the hearing officer pursuant to HAR 11-1-32, Mr. Jensen is permitted to associate himself with a member of the Hawaii Bar, in this case, Mr. Fitzpatrick, for the purposes of defending the Navy in this case. We had just confirmed on the record, or we are going to confirm on the record, the pleadings that are part of the record. As of right now, moving into the hearing today, there is an emergency order dated December 6th, 2021. The order regarding association of counsel dated December 9th, 2021. A scheduling order dated December 10th, 2021. An order partially lifting the stay dated December 10th, 2021. An amended order partially lifting the stay dated December 10th, 2021. And an order appointing substitute hearing officer, rescinding orders of prior hearing officer, and setting new schedule. And that's dated December 13th, 2021. Do I have the concurrence of both counsel that those are the pleadings and the full extent of the pleadings in the contested case to date?
You do, in fact.
Yes, sir.
So before proceeding with respect to matters specifically with reference to how the hearing tomorrow will be conducted, I would like to make a disclosure related to HAR 11-1-25 regarding who I am. So I have been appointed the substitute hearing officer. My task has been to conduct the contested case hearing in an impartial manner, a fair and impartial manner, which I firmly believe I can do. For the record, I am not currently aware of any case in which I represented the Department of Health in any matter as a party in litigation, although I did represent the state in matters concerning the Department of Health regarding the defense of COVID-19 regulations. There were several matters. I don't have all of them at hand, but one of them is called For Our Rights, which was a challenge to an emergency proclamation. Another one was entitled Kelly O'Neill's. It was a federal case regarding a challenge by bars regarding closures in the state of Hawaii, and they concerned matters that touched upon the Department of Health. Beyond that, I do know Deputy Attorney General Wade Hargrove. I am a Deputy Attorney General in the complex litigation unit of the Department of the Attorney General Office of the Executive Office of the Attorney General. Wade assisted me previously on perhaps two unrelated matters, but there is a wall that has been constructed between myself and Wade, Mr. Hargrove, for this matter. I have not looked at any documents, substantive documents concerning this matter. I have not been substantively briefed regarding the merits of this matter. I have no connection with any other matter concerning Red Hill. I do know that Deputy Attorney General Jay Page had a role in Red Hill. He's in another division. I just noted that he had been working hard on it. I don't recall that we had ever discussed any specifics on what he was working on outside of, certainly outside of the public domain. But I just noted that we had discussed the fact that he had been working on the case and had been working hard on it. I have read several news articles in the Star Advertiser, but I think it would be less than you could count on a single hand. And I have not seen any television news stories that I can recall. And that is the full extent of my disclosure. As far as HAR 11-1-25, I am not aware of any of the enumerated conflicts of interest which would disqualify me from participation in this case. And with that said, I guess we, well, let me just ask, just based on that submission, is there any objection to my my role as the hearing officer and making a determination at this time? And that's without waiver to any future objection that you may have, but just on the record for this time. Mr. Jensen?
So I would like to put on the record that the Department of the Navy does object to the supplemental order just recently released, removing Mr. Jacobson as the hearing officer and appointing you. It, at this stage, has nothing to do with any potential conflict of interest that you may have, and I trust your representations and don't challenge them. But we do believe that the Department of Health here has done two things. First, they were clearly unhappy with the orders that they were receiving from Mr. Jacobson, and therefore instituted a little bit of forum shopping, if you will. And then on top of that, truncated the schedule to eliminate, in my opinion, any possibility of a fair hearing, both with regard to my preparation for what is now tomorrow's case, when earlier or until this morning, it was a Thursday case. And also with regard to your efforts, sir, as the ultimate decider, you are not, in my opinion, going to be able to receive all the evidence we're going to give you tomorrow and be able to weigh it properly and enter into a final determination by Friday. So I think our challenge is not directed towards you, sir. It's directed more broadly to the supplemental order itself and to the firing, if you will, of Mr. Jacobson, and also the truncation of the schedule to such an extent that the Department of the Navy is not going to be allowed a fair hearing.
Mr. Hargrove, any response?
I would place on the record simply that is the nature of an emergency order, that it be dealt with in light of the emergency. The emergency is evolving rapidly, and the steps the department took to address the emergency were reasonable under the circumstances. If anything, they're even more reasonable under the current circumstances than they were. The threat has not abated. I don't think anybody's prepared to make any representations that they have in any significant way. Again, it would change the nature of the urgency with which the department's proceeding. So the setting of a hearing tomorrow is consistent with the expectation of the department at the outset of this proceeding that it would, with the filing of the emergency order, that this was in fact an emergency. And pointing out simply that the original date of the hearing was last Tuesday. So the Navy's been afforded an opportunity to prepare for a hearing that it should have reasonably expected would have occurred Tuesday when it was first notified that the hearing would be last Tuesday. And that's by virtue of the letter of the EO. The emergency order set forth a hearing of Tuesday. The delay, if you will, is a reasonable accommodation being made for these procedural aspects of the case to sort themselves through. And just state for the record that both parties have had the same amount of time to prepare for this case. Again, due to the fact that it was an emergency that presented itself. It is a situation that, from the department's point of view, the Navy has created. So the department is merely in the position of having to react to the emergency that the Navy's created. We are prepared to present our case. We fully expect the Navy to do so as well. And it is our confidence that the hearings officer will hear the evidence and have several days to weigh that evidence and render a decision in keeping with effort.
If I may be, sir.
Yeah, of course, please.
Okay. So the date we find ourselves at now, tomorrow as the trial date, is in no way is a reasonable accommodation. We didn't get there through the agreement of the Department of Health. Instead, despite the disagreement of the Department of Health, the actual date for the hearing as scheduled by Hearing Officer Jacobson was Thursday. And he did that in large part because he, unlike the Department of Health, does believe that the threat has been abated. Now, there are a lot of reasons why the threat has in fact been abated, but the most important for Hearing Officer Jacobson, and the reason why he scheduled the hearing for next Thursday as opposed to immediately, is because the Department of the Navy has suspended operations at the Red Hill storage tank facility. Excuse me, sir, I'll turn that off. And the only requirement of the executive order or the emergency order that has immediate effect is the suspension requirement. So under that analysis, as there is a suspension, there is no imminent threat, and we can move forward with the hearing at a more, not luxurious pace, but at a pace that allows the parties to properly prepare, and even more importantly, from my perspective, allows you the time to make the decision, to do the things you need to do to make the decision that you need to make. That was the basis behind which Hearing Officer Jacobson pushed the hearing date until Thursday. And that was, quite frankly, the reason why he was fired. So we are at a loggerhead here with regard to the Department of Health and the scheduling for the hearing. And I truly do believe we need an additional 2 days. And I definitely believe that you need more than the time they've allotted you in order to make a fair determination.
I would just briefly respond by pointing out that the department's position is that it does not have the luxury of time that the Navy seems confident it does. We do not share the Navy's view that the threat is diminished in any significant way. And we would ask that the order issue expeditiously for the very reason that that threat continues to need to be addressed in the way set forth in the order. More specifically, though certain steps need to be taken immediately, and certainly commendable, the Navy is acting proactively with respect to some things. There are other things that need to be planned for. They do not happen immediately, but that doesn't change the fact that the logistical preparations for those acts need to be underway as soon as possible to make it happen. I would also say that the department's not in the business of asking nicely and hoping for the best. The department's in the business of protecting public health and the environment. If the Navy wants to withdraw its request for a hearing and comply with the order, then there is no dispute. Their voluntary action, while welcome, is not subject to an order and therefore not enforceable as such.
Okay. So let me just say initially that the initial inquiry that I made was objection to my specific participation based on any conflicts. My understanding, Mr. Jensen, is with respect to my participation with respect to conflicts, is that you do not have an objection. Is that correct?
Not at this time, sir.
Okay. And that's without prejudice if something else should arise, or if I should have further disclosures in the future. But so with respect to that issue, then I will proceed. With respect to issues regarding the merits and questions about what's happening, I believe that ultimately that's going to be a question that we can discuss, obviously, or that we will hear about at the hearing, and we can talk about that more as we go forward with the hearing officer schedule. I do believe, and we can talk about, in addition to the specific scheduling that's in the order and how we can move forward. I will note that I believe that my authority as a hearing officer is limited to what is provided in the order, and is at least dictated by the strictures of that. At this point, I am inclined that we'll just have to move forward, and obviously we can discuss the specifics. Mr. Jensen, after we're discussing the specifics, if you'd like to re-raise some of the points that you've made that you believe are germane to the presentation of your case, we can hear that at that time. Does that sound reasonable? Sure.
Yes, sir. I believe you've properly put on the record that you feel you have no alternative but to comply with the order and its terms, and therefore there will be no relief with regard to the schedule, either with regard to its impacts on the Department of the Navy or with regard to its impacts on you and your decision-making process. I understand.
I would just like to clarify that what I said is with respect to some of the points that you specifically made regarding scheduling, as we're discussing issues such as, and let me just clarify, with respect to such issues such as witnesses, exhibits, if anything should arise that you feel is germane, we can address it within the context of our discussion moving forward.
Yes, sir.
So assuming, basically, let's just move forward with what's in the order. And what we have is a hearing tomorrow beginning at 9 o'clock. I have in front of me the emergency order. And there were, and if I may just state quickly for the record, there are 5 specific recommendations or orders, paragraphs of the order within the document. Is there, well, let me just ask, between the parties, is there, well, actually, let me just ask Mr. Jensen, is specifically, what is it that you intend to present evidence on at the hearing? And what aspect of the order do you seek to address? Oh, Mr. Jensen, are you on mute? Sorry.
Thank you, sir. The Department of the Navy challenges the entirety of the order. We believe that the justification within the order does not support a determination of imminent peril, which is required by the statute that the director purports to issue the order from. We believe that the conditions within the emergency order do not properly respond to an imminent peril, so that they too run afoul of the requirements of the statute. So we challenge all of the conditions on those bases.
And so this is 1, 2, 3, 4, 5.
Yes, sir.
Thank you for clarifying. Is there, may I just ask, is there any aspect of the order, I don't know, may I just ask both counsel or Mr. Jensen, has there been any talk of stipulations or agreed upon facts today between counsel?
We haven't had those discussions. I will represent that the background section of the order, which identifies a series of factual statements, we are not at this stage. Well, I haven't reviewed them for purposes of entering into a stipulation. I am not aware of any information within those facts, within those statements that are incorrect.
And you're referring to, I believe, the background section on pages 2 and 3?
Pages 2 and the upper part of page 3.
Correct.
Yes, sir.
But you do, may I ask, with respect to the additional justification, I believe that you had said that you contest that.
We contest the claim that those statements are proper justification for determination of imminent peril. Yes, sir.
And Mr. Hargrove, I'm not asking these questions to discuss the merits. I'm just trying to determine the scope. So I'm not asking for a response at this time.
Understand.
Okay. Okay, let me begin with this and the nature of the presentation of the hearing. May I ask, let me begin by asking Mr. Hargrove, what you believe is the proper order of presentation, and I mean that by either DOH presenting first or the Navy presenting first, the burden that's proper for the hearing officer and ultimately for the director or deputy director to apply, and any other standard issues. I'll just begin with Mr. Hargrove, as the Department of Health is the one who issued the emergency order.
I'll make these representations with the understanding that Mr. Jensen and I have actually had some, I think, productive conversations about reaching an understanding between ourselves about how things may proceed. I think I can represent that the typical or pro forma way of proceeding at hearing in these matters where they're involving an environmental action and a contested case, a request for a hearing by a respondent in one of those actions. Normally, the state has the burden of production and of proof, the standard being provided in Chapter 91 of a preponderance of the evidence presented to the hearings officer for his or her decision, or in this case, recommendation to the final decision maker. And I would suggest that the way we would proceed is that I would present, Navy would present, the Navy would have an opportunity to argue, and I would have an opportunity to argue. And again, just to try and keep things moving, Mr. Jensen was kind enough to provide me time this morning to discuss his expectations, and of course I will allow him to speak for himself, but I think we are fairly in agreement that each counsel of the respective client would have an opportunity to provide a brief opening, present their case, again with the Department of Health, me presenting first. So counsel for Navy following, then there would be at that conclusion of the receipt of the evidence by the hearings officer, there would be time allowed for Navy counsel to present an argument of the Navy's position vis-a-vis the evidence admitted or presented, I should say. And likewise, I would then close with argument stating the Department of Health's position with respect to the evidence that was presented.
Mr. Jensen, do you agree with that, or I guess the statements of Mr. Hargrove that Department of Health presents first, the Navy responds, followed by closing argument? Do you agree with that order of presentation? This is
yes, sir. Yes, sir, I do agree with the order. I do want to clarify that the recitation that I was understood Mr. Hargrove to just talk to was he does an opening, he presents his case. I do an opening, I present my case. I argue, he argues. And that's I believe the agreement we reached earlier.
Okay.
He's shaking his head in affirmative.
So let me just restate that. Department of Health opening statement, the Department of Health presentation of the evidence, Navy opening, Navy presentation of the evidence, Navy closing, DOH closing. Did I get that correctly, Mr. Jensen?
Yes, sir, that's my understanding.
Mr. Hargrove?
Yes, that is my understanding as well.
Sounds reasonable to me. Let me go back to Mr. Hargrove. Mr. Hargrove, what is the burden of proof in this case, if you're prepared to speak on that? And who bears the burden?
As this is an action taken by the Department of Health and fairly unambiguously prejudices the Navy, I would argue that the Department of Health has the burden, and that burden, according to Chapter 91 of the Hawaii Revised Statutes, the burden is defined as a preponderance, and I can find that citation. And of course, if I,
It's in chapter 91, correct?
that is correct. I believe it is section 10, chapter 91, section 10(5), which is that quirk in our revised statutes where you have a number and a number for Mr. Jensen's benefit. It's 91.10(5). In contested cases, setting forth the except as otherwise provided by law, the party initiating the proceeding shall have the burden of proof, including the burden of producing evidence, as well as the burden of persuasion. The degree or quantum of proof shall be a preponderance of the evidence. That's how I read that section. For purposes of this proceeding, I'm prepared to take the position, although I would ask respectfully the opportunity to reconsider, given the fact that we'll be conducting additional research. But my understanding and impression is that the burden will fall on the Department of Health, as it has initiated this action, notwithstanding the fact that this is technically the Navy's request to contest it. I view the initiation as the filing of the emergency order.
Thank you, Mr. Hargrove. Mr. Jensen, I assume that you agree that with Mr. Hargrove that the burden is Department of Health's. Do you agree that preponderance of the evidence is the standard? And this is obviously a pure question of law. I just want to make sure moving into this that that the parties are at least in agreement with this.
Yes, sir. Mr. Hargrove and I had a conversation about the burden of proof earlier, and what he represented is what we talked to. I obviously agree that they have the burden with regard to the burden of proof, or as to whether it's preponderance of the evidence. I'm at a disadvantage as I am in a different room than my Lexis research capability, but I'm presuming he correctly read the statute, I'm sure.
Thank you. All right, let's just quickly begin, and just so I can get a kind of a general sense. Mr. Hargrove, as you will be going first, I was wondering if you could advise, well, let me back up. Have the parties stated at least who they intend to call as, or potentially call as witnesses, and potentially what exhibits they intend to use?
And with Mr. Jensen's permission, I'll just jump in here. We have, and again, I thank Mr. Jensen for his willingness to discuss these matters with me, because that has, I think, put us in a position to have a meaningful conversation about this. We have exchanged our thoughts with respect to how evidence would be presented and what the nature of that evidence would be. I'm reasonably confident, since we have had discussions throughout the week, frankly, that that we really have kind of crystallized around what our respective cases are going to look like. So I can represent at this time that my intention is to call 3 witnesses, 3 persons, all employees of the Department of Health. And for the record, their names are Lene Ichinitsubo. She is the chief of the Solid and Hazardous Waste branch of the Department of Health. And she is both nominally and effectively the kind of administrator or project coordinator of the of all things Red Hill, is the way to say that. And I would characterize the second witness as also heavily involved with the department in matters related to Red Hill. Her name is Phoenix Grange. And she is the, I believe, program manager, and I'll get some clarification on her official title, program manager of the Hazard Evaluation and Emergency Response program within also the Department of Health. That is an office of the Hazard Evaluation and Emergency Response. She, like I said, has had extensive involvement in the work the department's done to manage this crisis, and previously with respect to trying to address Red Hill as a larger ongoing concern. The final witness will be Diana Felton, and she is the state's toxicologist. So she is also a Department of Health employee, and she, her training and expertise is in both emergency medicine and toxicology. I believe that will be all I need.
Okay, and approximately, have you guys exchanged exhibit lists?
We have not, and again, Mr. Jensen, feel free to jump in here, but just for efficiency's sake, we have not yet done that, and we were just discussing this earlier today. We do need to do that, but we've had a lot of discussion about what they're going to look like, what they'll likely look like. I am hopeful that I will have an exhibit list soon that I can present to him so that he can review that. But we've had a discussion about the nature of the documents we intend to present, and I think we have a general understanding, again, between the parties, counsel, as to what these will look like. They are in the nature of things that, in the state's case, in the Department of Health's case, this is going to be material that will be familiar to the Navy. And I believe I can say that reasonably confidently, that without exception, it will be material that has already been presented to the Navy, and with one exception. And that's going to be the presentation that we provide tomorrow for purposes of navigating the hearing. As I've informed Mr. Jensen, the department will be presenting a slideshow, if you will, for lack of a better term of art. It's a PowerPoint demonstration, which will cite to the relevant documents that will be the exhibits that are admitted, or that we will hope will populate the hearings officer's record of, for this matter.
And this is a demonstrative exhibit.
That's correct.
Is it complete?
It is 75%.
Would you agree that when you complete it, could you please send it to Mr. Jensen separately, just so that he's aware of what's in it, so that he can have time to review it?
I will do that, and like I said, I'll also owe Mr. Jensen an exhibit list, which I'm also presently working on.
May I ask? Well, let me just begin because we're dealing with opening statements, so we're going to talk about opening statements first. I'd like, if possible, well, let me just begin by saying I would invite the parties to submit any sort of kind of pretrial brief, to the extent that they have one ready before the hearing, and I would do everything that I could to review it before the hearing, just to expedite things. And so that's, everybody has permission to file a pretrial brief about what they expect the hearing to consist of and what the legal points would be. But with that said, my inclination would be to keep openings relatively brief to the extent that we can, and we're going to have a presentation of evidence. But I'm just going to ask the parties, beginning with Mr. Hargrove, approximately how long would you be requesting for an opening statement?
I would suspect that 5 minutes would suffice, because I too, for the reason that I too would prefer to just begin presenting evidence relatively expeditiously.
Excuse me. So with respect to your presentation of evidence, how long do you expect, if you had to just give an approximation of how long that would take to present?
I hope not to take 3 hours, but I certainly respect Mr. Jensen's need for equal time. So what I was thinking, and again, this is just my thinking on this, is that both parties would have time to present evidence, make argument, and it would be my preference that the hearings officer be afforded time to ask questions of any witnesses that have been made available at the hearing. That would be my preference. And of course, that's your decision to make. So that's how I would ask that we at least consider a block of time, an equal block of time, and then the remainder to be reserved for the hearings officer's inquiry if necessary. So the answer to your question would be three hours, I believe, is sufficient, given that the Navy would need equal time.
Okay. Well, before getting into this idea of equal time, what I'm hearing is opening statement 5 minutes and approximately 3 hours for the presentation of evidence. Is that correct?
That's correct. Thank you.
It consists of 3 witnesses and approximately how many exhibits?
I need a better ballpark than this, but my guess, my estimate is in the nature of less than 30. My understanding is 20, 25, something like that. Again, these are documents that are that the Navy will be familiar with.
Okay. Anything else you would like to add, Mr. Hargrove, before I move on to Mr. Jensen?
I guess I would just add that with respect to closing arguments, 10:15, in the nature of that, subject to what Mr. Jensen thinks is reasonable.
Okay. Mr. Jensen, why don't we begin just with an opening, just the what the Navy would be requesting as far as an opening. Mr. Hargrove said 5 minutes. I'll just allow you to present your thoughts.
5 to 10 minutes would be sufficient, sir. No more than 10.
Mr. Jensen, approximately, and I assume that Mr. Hargrove had not given you, I believe, a witness list or exhibit list. I assume you have not provided that to Mr. Hargrove yet either. Is that correct?
He hasn't given it to me in writing, but the representations he made to you were made to me before, and I made similar representations back.
Okay,
and I'm happy to talk to you about them.
Okay. Approximately how many, or let me just ask, how many witnesses do you intend to call on your case?
Yes, sir. We have 6 witnesses, all 6 given the truncated time that we have. And I spoke with Mr. Hargrove about this. All 6 witnesses will have declarations. 2 of the witnesses will come in and testify. Through one of the witnesses, the declarations of the other 4 will be authenticated and admitted or offered for admission. Those non-testifying witnesses will be available should you or the Department of Health wish to examine them. But given the short amount of time we only have tomorrow, we were making choices as to who would testify. My 2 testifying witnesses are Jim Bellotti. Jim Bellotti is the Principal Deputy Assistant Secretary of the Navy for Energy Installations and Environment. And Captain Horniak, who is the Commanding Officer of Fleet Logistics Center here at Pearl.
Mr. Hargrove, do you have any objections to the presentation of declarations to 4 witnesses subject to the reservation regarding possible examination? Well, let me just ask you this. Are you know who these 4 witnesses are, Mr. Hargrove, who would be testifying by declaration?
Mr. Jensen has mentioned their names to me during conversation, yes.
Yeah, but you haven't seen the substance of the declaration, is that correct?
I have not.
All right, so basically, subject to the reservation regarding potential cross-examination by either, or I should say by Mr. Hargrove, or any questions I might have, do you have any objections to 4 witnesses presenting declarations in lieu of direct testimony?
I do not.
And I have a proposal with regard to the delivery of our exhibits. to each other and to you, sir. I would recommend that given the truncated nature of the hearing tomorrow and all that we have to review, it would be good to get on it. And so I would propose that the parties share their exhibits and their briefs, and pursuant to your thoughts, sir, I would advise that the Department of the Navy will submit a hearing memo or a pre-hearing memo, but submit their briefs, their exhibits, to include declarations and documentation by, and I haven't coordinated this time with Mr. Hargrove, and I'm willing to hear other options, but I was going to suggest 8 o'clock tonight. And I would appreciate if we do that, that if there is, after review of the declarations, for example, of the non-testifying witnesses, an idea that one or both of you would like to have one or more of them called, then I'd be put on notice as soon as possible, so that I could arrange for them to participate in the hearing.
Mr. Hargrove?
I can agree to that. I think that's a reasonable request, and certainly likewise an accommodation if I receive those declarations, have a chance to take a look at them, and I will certainly make a representation, Mr. Jensen, if I feel the need to in any way cross-examine those witnesses, and we'll be more than happy to let him know that today or tonight. I'm also comfortable with the idea of trying to meet this 8 o'clock deadline to exchange exhibits. That's reasonable.
Okay. Well, so let me just begin by saying that it seems that we have on the record an agreement between parties that by tonight, and you confirm if I'm correct or incorrect, by 8 o'clock tonight, parties may submit a pre-trial, or pardon me, a pre-hearing brief, witness list, exhibit list, and exhibits. Is that correct?
Yes, sir.
That is correct.
Okay, so ordered.
And we will share those with you too, correct, sir?
Oh, yes, and I was just about to get to that. Just make sure. Okay. And so with respect to submissions, the hearing officer, in lieu of a formal filing, I would suggest that the paper pleadings, and by that I mean the brief, the witness list, the exhibit list, be served upon the hearing officer by email. I believe, let me just put my email on the record. It's david.d.day@hawaii.gov. I believe that I should also be on the calendar invites to this hearing that was given earlier. With respect to exhibits, I think it makes sense. Oh, and that would go for the declarations as well. If the declarations of, or I should say the declarations in lieu of direct testimony, those can be emailed to me as well. With respect to the exhibits, I would suggest that they be provided to the hearing officer via some sort of either Dropbox or some sort of software like that. Do we have may I just ask, Mr. Hargrove, do you have a naming nomenclature for your exhibits? Like,
yes,
you know,
the party, yes. Mr. Jensen and I have agreed that I'm using numbers, he's using letters for purposes of labeling the exhibits, and we both agreed that we would go ahead and label those exhibits. We'll the list that I intend to provide to counsel and to the hearings officer will set forth the number and a description of the exhibit. So I think Mr. Jensen was going to do the same.
And with respect to the exhibits, once they're exchanged, I would like counsel to consider what exhibits they would have objections to the admission of, and what objections they have no objection to, so that we can just at least address the admission issue before the presentation of evidence tomorrow. Does that make sense?
It does, and again, just jumping in, Mr. Jensen, please correct me if I'm mistaken, but we did have a discussion just to try and preliminarily reach some kind of understanding between ourselves about how evidence would be treated by counsel. We, I believe, have agreement with respect to their admissibility. Again, assuming my representation is accurate, that the Navy is in fact being presented only with things that it's familiar with, and again, I expect no surprises in that respect. And I think Mr. Jensen's description of his exhibits to me earlier today and previously during the week would be consistent with my expectations that they not be things that I would be objecting to. And then just to cut to the chase, I believe there was one item that the Navy intended to present that was somewhat presented some questions. I would just characterize it as just it raised a concern about its appropriateness on the record, and it would be just this matter of and Mr. Jensen, I don't know if you want to represent that exhibit or if you'd like for me to, but do you have a preference?
No, I know what you're talking to, and I'm happy to talk about it. I would like to offer that your representations to the hearing officer that the documents you're going to present are documents that the Navy is familiar with. It's a big Navy, and I'm not all of it. So I appreciate that that the documents you present will have at some point in time been available to someone in the Navy, but we'll have to take a look at them. All that being said, from how you described your documents, I do not believe that I will have any objections. And it is fair to say that from how I described my documents, you had one concern, and this is in fact with a document that the Department of Health is aware of, because in fact the document came out of litigation with regard to an issue on Red Hill. And that document is the hearing officer's findings of fact, conclusions of law, and recommendations with regard to the contested case hearing for the application by the Department of the Navy for a permit to operate the Red Hill facility. And I advised Mr. Hargrove that is the Department of the Navy's intent to submit that document as an exhibit. And then also additional exhibits would include some of the documents considered by the hearing officer, which include reports and studies that are otherwise available publicly on an EPA website, and could, obviously are separate from the hearing officer recommended decision. So we're going to submit that as one of the exhibits, and my understanding is Mr. Hargrove is going to take a look at it, and if he does raise an objection tomorrow, I recommend that we deal with it then.
I'll just say to the extent, actually, let's just address it tomorrow, but I would ask both parties to be prepared to address that. And obviously, if Mr. Hargrove doesn't have an objection, then that's fine. But we'll be prepared to address that first thing in the morning. Does that make sense?
Yes.
Mr. Hargrove?
It does make sense, and I do think it might be, given the fact that things are moving rather smoothly right now. I think maybe we want to carve a tiny bit of time, if I may, to just address that now, since it's only my potential objection, just to describe the nature of that concern.
I think that it makes it, because do you know exactly what's in the document or not?
Well, I know what the document is. It's what it is that's the concern, not what's in it, actually.
Why don't let's reserve this for tomorrow so that we can just all look at it and I can look at it as well.
And I just would make one further representation that Mr. Jensen has made it clear that there are records that were introduced during that proceeding. I have no objection, will have no objection to the admittance of or introduction into the record of those records that were relied upon during that proceeding. So it's just the proposed finding order.
Okay. So let me just say that, I appreciate that both parties seem to be seeking to try to, come to agreement where possible. But tomorrow, when you guys both have your formal exhibit lists, obviously this is without prejudice to any objections you may have tomorrow.
So can I offer up one observation, sir?
Yes, please.
Okay. So Mr. Hargrove and I've worked together cooperatively, I think, to try to carve out something that makes sense and is digestible for the hearing officer in the time he has to make the decision he needs to make. And one of the reasons why the Department of the Navy believes that this exhibit, the findings of fact, conclusions of law, and recommended decision of the hearing officer in the companion case is a very good vehicle to help the hearing officer decide what he needs to decide in this case. It's a guideline, if you will, to the evidence that supports the Department of the Navy's position in this case. And we offer it, obviously not as testimony, it's instead documentation. And it may in fact be hearsay, but that's okay. Hearsay, federal evidence relaxed, and hearsay is admissible. But it's helpful to you to understand the back and forth between the parties as viewed by an independent third-party arbiter, in fact, a hearing officer from the Department of Health. And in addition, if it were not available to us to provide to you for that back and forth, then our substitute would be literally every exhibit that was filed in that contested case hearing, which, for the record, went on for 2 weeks back in February of this year, and then was reopened in May of this year, so that there was actually additional exhibits filed. I have been working hard to try to develop a record that meets both parties' intents of, if you will, judicial economy, so that you can make an informed decision. I understand that this is another hearing officer's decision with regard to another case. I understand that you will give it the appropriate probative weight. I'm not asking for you to make a determination that, well, if this hearing officer said it, then it must be true. Obviously, that's not what you would do. But it does tell a concrete story from someone who is independent, neutral, and qualified to make the analysis with regard to all the evidence that was presented to him. And I believe it's important for you to hear it, if for no better reason than to just get a baseline of what's going on here and then make your own determinations. Again, hearsay, yes. Probative, your determination, but it needs to be put into the record, sir.
Okay. Mr. Hargrove, I'll just note that I'm going to reserve a determination on this just until I can see it. But just because there was a statement there, I'll just give you if you'd like to just address anything that was said, I would just suggest that we could just wait until tomorrow.
That's perfectly fine with me, and I would just thank Mr. Jensen for his description of the situation, because I do think it was in the interest of the parties and the hearings officer to just have a kind of a preview of what the issue was. As Mr. Jensen represented, it's one of the few areas of concern that I had with respect to the evidence in the making of the record. So, and I would just point out that I do appreciate Mr. Jensen's effort to introduce evidence in a way that is fully formed and digestible. So for purposes of rendering a decision. So I'm definitely not lodging an objection now. And as you said, I have not yet seen it either. So I appreciate that we will take this up tomorrow morning.
Okay. And Mr. Jensen, just to round things out, given obviously there's an issue, I guess a variable about whether or not any of the declarant witnesses would be asked to testify. But may I just get a ballpark of, to the extent that, let's just assume that that they are not, what would be approximately the length of time for your presentation of your case? If I could just have an approximation.
I think 3 hours also, sir.
Closing statements. Obviously, we're going to be, and we'll talk about this in just a moment, proposed findings of fact, conclusions of law, and any closing brief. But I would, I'll invite if it seemed like you guys had agreed to do some sort of closing presentation. Did you guys come to any sort of agreements on length of time? If not, you can just, I'll just throw out suggestions and that would be fine. Let's go with Mr. Hargrove first. Or actually, let's go with Mr. Jensen first. He would be presenting first.
I don't anticipate a closing that's longer than a half an hour, sir.
Mr. Hargrove?
I too need no more than half an hour.
Okay. With respect to proposed findings of fact and conclusions of law, my hope is that based on the presentation of the facts, and that would be something that could be done relatively quickly. I like to suggest the 15th, Wednesday 15th at the close, I should say at 11:59 p.m. But I will, let me just ask Mr. Jensen first, with respect to findings of fact and conclusions from law, the timing for submission to the hearing officer and the opposing party, if you have any, that would be acceptable, or if you have a need for something else.
I hadn't actually even contemplated that. I believe that we could provide by close of business Thursday, findings of fact, or Wednesday.
Close of business.
Wednesday, recommended findings of fact and conclusions of law.
Mr. Hargrove?
I believe that is a schedule that I too can keep.
Okay. With that stated, I will ask, let me ask Mr. Hargrove first if there's any other matters prior to tomorrow's hearing that they would like to raise with the hearing officer.
Nothing further at this time.
Mr. Jensen?
Yes, sir. I have several things.
Please.
First, backing up to something you talked to earlier, provision of a witness list and an exhibit list. Do you want those lists provided at the same time we provide the exhibits? And if so, then is there a need for the exhibit list? Because by providing the exhibits, you're on notice of what the exhibits are. I guess is what I'm trying to ask.
I think an exhibit list would be helpful to the extent that it wouldn't be difficult to put together. Is there some concern with the exhibit list?
No, I just thought it's superfluous of actually providing the exhibits.
I think it would be helpful just for the record, so that we can, if to the extent that everything comes in, then that would be something that we could address. And it's also just something that that we could have as an official record of what's admitted and not admitted. So I would respectfully request, to the extent that one's possible, that we could have that just submitted at the same time.
Very well. And with regard to large files, you had this discussion of providing some file sharing service. Is that something that the hearing officer is going to provide, or how are we going to move forward for large files?
May I ask if the Navy has a service like either SharePoint or OneDrive that you use? Perhaps it would, I don't know if it would be a secure type thing, but may I just ask, because I actually don't know how that works on our end. So I guess if you were going to submit large files to somebody in the Navy, within the Navy, how would you do that?
We use something called DoD Safe, but that I do not believe will be available for this purpose.
If I may offer up a possible solution.
Yes, please.
Thank you. I believe that the Department of Health has the capability to provide and this is, I believe, SharePoint. And when I say the Department of Health, there is an administrator within the department that can provide a file into which via email, into which documents can be populated. They would be PDFs, of course, and would be accessible via links distributed to counsel and the hearings officer. So it would be a hearings officer's file. And I think we can get the Navy stuff in there with their exhibits enumerate or alphabetically organized, and the Department of Health's exhibits numerically organized. And again, I think we can make access available. And so in the interest of transparency, I had begun that conversation with the folks within the department that I work, so that we could facilitate a place, a reservoir, if you will, for the files to be placed so they can be reviewed by you, the hearings officer. So to finish that representation, I think that can be done, and steps were taken to make that possible. So I think all that we would need is a link to that file folder, again, accessible through the internet. And I believe that someone at the Navy, there are people, I know for a fact, there are folks at the Navy who have shared files with the department in this way, and I'm sure they can help populate it with the Navy's materials, these exhibits. And I likewise will communicate with this person at the department and populate the Department of Health's exhibits similarly.
So if I am, just so I'm clear, it sounds like you're going to be providing Mr. Jensen with a link that he would be able to save files to. Is that correct?
That's correct.
Okay. Does that sound good, Mr. Jensen?
I honestly don't know if that will work. For example, I am currently participating in this Zoom link from a what we call an MCI computer, because my MCI computers would not connect. The link was viewed by Navy Marine Corps intranet as unsafe. So whether or not I can access a link to load large files that's provided to me by the Department of Health is an unknown right now.
Okay. Mr. Hargrove, could you make that the first thing that you do? And then Mr. Jensen, could you also make that the first thing, just to determine whether or not that would be something that you could move files into? Because then otherwise we might be able to work something out. Otherwise, I don't know. So does that sound good to you, Mr. Hargrove?
Absolutely. Yes, sir. I will proceed to do that immediately after this call. And as I said, I'm in contact, I have been previously, with the person that I believe that can facilitate that. And and I know Mr. Jensen doesn't have personal familiarity with that, but I do believe there are folks within Navy Command that have Navy Council even that have local council, of course, or I should say, I guess the term for it would be the command within the command, who have some experience with this. And I think we can get this done. I'll go ahead and get that underway now. And I just, for Mr. Jensen's benefit, I believe the first step would be providing him with a link access. So if he can represent that he will be able to get the PDFs he needs, he should be able to, and again, pursuant to the use presumably of a non-DoD safe computer, but can send those PDFs to this link. I believe that's the easiest way. So if he can get the PDFs on his computer, he can send these PDFs to the file via an email. So, but we'll experiment with that, make sure it works, and report back to you as soon as possible.
I will just offer that if the file is small enough that it can be sent via email, then perhaps we should forward to each other the exhibits in batches, as opposed to trying to find a file share service that complicates matters significantly.
Okay. Let me just say this. To the extent that there's any issues, just get them to each other however you can. I think that in good faith, I think that makes sense to me. Good.
So the next question I have, or comment I have, is I do anticipate one or maybe even more exhibits that my witnesses will talk to that are, I won't call them maps. They're controlled and classified information. They're schematics of the Red Hill complex, and therefore are not proper to be viewed by the public. I've spoken with Mr. Hargrove about this, and our intent going forward is that when a witness testifies and refers to an exhibit, Mr. Hargrove, I and you will have the exhibit, but I will not, as it's my witness and I would otherwise do, I will not share my screen so that all parties and of course the public can see the exhibit, because that would allow all those on YouTube to see controlled and classified information. Instead, the witness will, as best he can, identify what he's talking about on the exhibit with exhibit references. But the only persons to review the exhibit are those that have it: the hearing officer, Mr. Hargrove, myself, and the witness.
Okay. Well, let me just make sure that I understand. So there are some exhibits which contain classified information. And when you're using classified, oh no, pardon me. Could you please explain, because I misunderstood?
Yes, sir. Controlled unclassified. It's not classified information. It's controlled unclassified, which means it's sensitive material and should not be released to the public, but it is free to be shared with state agencies and regulators. And we commonly share controlled unclassified information with the Department of Health. The Department of the Navy has no concern with providing these materials to Mr. Hargrove, to you, but we can't share them openly with the public.
May I ask, is this, so I assume if you're going to be presenting it, it is germane and relevant to your presentation?
Yes, sir.
Okay. Just one moment. Mr. Hargrove, do you agree with that statement? Or basically with that arrangement? Generally.
I do, and again, I think the significance here is that Mr. Jensen will be making the exhibit available to you for your review for purposes of informing your decision, which I view as the critical element here, and I will be able to review it as well. As Mr. Jensen knows, I have been very involved in trying to manage the process of the state providing records that the Navy often has a claim of protection that applies by virtue of federal law. So I'm sensitive to the issue that he's raised. I'm familiar with the issue that he's raised, and I have no objection to the process especially in view of the fact that I intend to engage in a procedure with respect to my presentation of my case that also takes into some account this concern about the security issue. This is the critical infrastructure that the Red Hill facility is described by the Navy as being. So the way in which I would present my evidence, as alluded to earlier, would be by way of a PowerPoint presentation with questions to live witnesses. Again, the three persons identified earlier. And they would be making references to exhibits that I have introduced. Those exhibits themselves will not be on display, but will be available to the hearings officer for reference, and of course will be available to the witnesses and counsel for their reference. And again, the idea being that in the unlikely event, and again, I feel reasonably confident that there is nothing that is in the record that I intend to create that is critical infrastructure security information. And I believe, Mr. Jensen, you described it as
Controlled unclassified.
Controlled unclassified, right. I don't believe anything is in that nature. I have reviewed the majority of the slides. There are a few that had not yet been created the last time I looked at it. I don't see any of that. But in an effort to be overly cautious, I would characterize this scenario. I'm going to not project the document, the exhibit itself, but rather make reference to it with a citation for the hearings officer and counsel and witness to refer to. And then, of course, again, that exhibit is going to be included into the record. And I would say simply that it's my view, real quickly, my view is that this record does need to be made public. It will be a public record. And then the question of, at least with respect to the evidence I present, I don't see any issues. I think Mr. Jensen's representing that there are one or two things that may need to be, I guess, in the discretion of the hearings officer, potentially redacted before distribution publicly.
Well, so let me just ask this, Mr. Jensen, is controlled, so I'm unfamiliar with this, is controlled unclassified information protected from disclosure under federal law? Mr. Jensen, you're on mute, I believe.
I apologize. Yes, 10 USC 130E is an example of a federal statute that protects controlled unclassified information to include information regarding facilities, which is what we're talking to here. So,
may I ask if entire documents are controlled unclassified, or is it just certain segments of documents?
for purposes of what
That contain controlled unclassified.
for purposes of what I intend to insert within exhibits, it will just be portions, and they will be marked. The pages will be marked.
The pages will be marked. Okay. If those documents, I think this makes sense. So pursuant to the extent that we'll formalize this in order, but and to the extent that Mr. Hargrove doesn't have an objection, and we can kind of go through the specifics of it tomorrow, but pursuant to HRS section 92F-13, subsection or paragraph 3 and paragraph 4, it would seem that paragraph 3 states government records that by their nature must be confidential in order for the government to avoid the frustration of a legitimate government function. And then paragraph 4, government records which pursuant to state or federal law, including an order of any state or federal court, are protected from disclosure. So pursuant to those representations, I believe we just need to be careful. And Mr. Jensen, I'd ask that you sort of take the lead in making sure that we're aware of when we're dealing with these types of information, but that I will find that subject to any objections tomorrow or anything that might arise, that these are protected from disclosure. And we will try to fashion some sort of order that will ensure that that remains the case, while also being able to advise the hearing officer and the ultimate decision maker of the judgment or the decision of the court, or pardon me, of the hearing officer. Does that sound reasonable? Some sort of protective order on that?
Yes.
And with respect, actually, Mr. Jensen, may I ask you, and this, we don't have to do this just right now, obviously we have the hearing coming up, but may I ask you to fashion some sort of language that you think would be appropriate for a protective order, and then just run that by Mr. Hargrove, and then you can submit that to the hearing officer. One that obviously protects the public's right to free access of information, while also protecting the specific pages that you believe are subject to controlled unclassified protection. Does that sound reasonable?
Yes, sir.
Okay. Mr. Hargrove?
No objection to that.
Okay. Mr. Jensen, anything else at this time?
The Department of the Navy would request a transcript of the proceeding, obviously.
Okay. Now let me, I don't know, I believe it would be a recording. May I ask the Department of Health representative who's on right now, if you can make me aware of how the transcript will ultimately, the transcript of both this hearing and of the hearing tomorrow will be prepared. Is it a transcript? Is it a recording? What will be the record that will be provided to the council, if you know at this time? Okay, so I'm being told that this is recorded, and a link will be provided to the recording. So I believe that there will not be a transcriptionist. It will be a video. Mr. Jensen, is there anything else at this time?
No, sir.
Mr. Hargrove, any last thing that might have come up? Or are we ready? Are we good?
I think we are good.
Okay. I will. So let me just very quickly just go over just kind of the main points with respect to the presentation. The presentation of evidence tomorrow will be Department of Health opening, the Department of Health presentation of the case, Navy opening, Navy presentation of the case, Navy closing, Department of Health closing. Opening statements will be approximately 5 to 10 minutes. Presentations of the case will be approximately 3 hours. Closing statements no longer than 30 minutes. With respect to 8 o'clock tonight, any pretrial filings or pretrial briefs, witness list, exhibit list, exchange of exhibits, demonstratives will be exchanged at 8 o'clock tonight. Mr. Hargrove will be providing a link to Mr. Jensen to the extent that there's a problem with that. We're going to be using emails. Mr. Jensen, I just thought of one more thing with respect to the classified documents, or not the classified, the controlled unclassified documents. If you could please make sure that those are marked either in the file, or if it's going to be sent by email via a separate designation, maybe a separate email that just says that these are the unclassified ones, just so that there's no confusion for anybody about what is unclassified, or pardon me, controlled unclassified information. Does that sound reasonable?
It does. I would just offer that that direction should also go to Mr. Hargrove, because it sounded to me like he anticipated some of the documentation within his exhibits may also be controlled unclassified.
Mr. Hargrove, is that true?
Yes, the idea was, I don't know that any of it is. I think the idea was that if the presentation during the hearing was demonstrative rather than the actual exhibit, that we wouldn't have an accident. That's the idea. And that the Navy would have an opportunity to review the exhibits, and it would never leave the control of the hearings officer before such time as the Navy had an opportunity to say that they had a concern, raise that concern with the hearings officer with respect to making that then hearings officer record public, right? The exhibits there in the possession of the hearings officer. So
I have good news.
Yeah.
I have good news and an observation. So the good news is that the transmission of controlled unclassified under normal internet between the federal government and state entities is permissible. So there's no concern there that we would run afoul of any requirements. Once we receive Mr. Hargrove's exhibits, most probably after the trial, we will review them and assess whether we believe any are controlled and classified, as he is not aware. Since he tells me that some of them are from us, we can at least do that and make a determination and include that in this draft protective order. Beyond that, I don't know that there's much we can do right now on that.
Okay. I just want to be very careful, and I'm very cognizant of this issue. I just want to make sure that we don't have any mistakes. And so, just the extent that we can just always be aware of this, I'll try to keep an eye out to the extent that I can. And then I would ask that the parties do so as well.
Yes, sir.
And let's see. We have proposed findings of fact and conclusions of law by Wednesday, the 15th, 11:59 p.m. Hawaii Standard Time. The video or the hearing tomorrow will be video. This hearing today, I believe, is also on the record and will be available by video at some point. I don't know if it's going to be today. May I ask the Department of Health representative if the recording of today's hearing will be made available to council? Sure, that right after the hearing, in case there's any reference that needs to be made. Other than that, is there any, well, let me just ask, is my recitation of the basic schedule correct? Does anyone have any issues with what I just said?
No concern, sir.
None, thank you.
I will try to get out an order. I'm just memorializing this sometime in the next several hours. And otherwise, I believe a link will be going out to you gentlemen in either this afternoon or tomorrow for tomorrow's hearing. If any issues should arise between now and tomorrow that need to be addressed, you can email me. I would hope that we can avoid that, but to the extent that something does arise, please let me know, and please let me know if there's any issues with the technology. Okay.
So Mr. Jensen and I will get to work right now. I will get to work on my end, making sure that we've secured a vehicle for the exchange. As you said earlier, we will be exchanging PDFs via email to the extent practical. I will, but I'll go ahead and make sure the department is prepared with a SharePoint file so that it's available for our use if need be, and of course if it winds up being the most convenient mechanism for the hearings officer.
Okay, I understand. Good. Thank you very much, gentlemen.
Thank you.
Have a great day, everybody.
And we are off the record.